Uh, Good evening, friends. As you all know that the last webinar which we had with Justice V Ramkumar, that was from Dubai, and those sessions have actually done. But after that session, we all know that BSA, BNSS have come into being, and there's a lot of debate as to what are the changes brought forth. And in that endeavor, whenever things come upon us, we always bank upon Justice V Ramkumar, a former judge from Kerala High Court, to share his knowledge and perspectives. Therefore, the interplay or the changes which have come forth in Section 145 of the Evidence Act, and which now presently is under the corresponding act of Section 140 of BSA, that is in respect of contradictions. We had requested Sir, and as usual, Sir has been kind enough to accept our knowledge for sharing his knowledge on our platform. Those who have missed the series of webinars which Justice V Ramkumar has shared with us, it also gives us a sense of pride to the fact that he has been acceding to our request in our legal journey process of sharing knowledge. Without taking much time, I will ask Sir to share his knowledge. And thank you, Sir. And we hope that you continue to share your knowledge and keep maintaining good health. Over to you.
Thank you, Mr. Vikas. Good evening, friends. Any lecture on, we are going to deal with contradictions only. Corroboration, we will defer it to yet another article or yet another lecture. See, any lecture on contradiction in the context of criminal trial will not be complete without reference to the celebrated verdict by a 6-judges constitution bench in Tahsildar Singh versus State of UP, AIR 1959, Supreme Court 1012. There were 6 judges. Unusually, there is an even number of judges. Usually, there is a odd number of judges in like 3 judges, 5 judges, etc. when a matter is referred. But here, unusually, it is 6 judges constitution bench. The great judges were V.P. Sinha, Said Jafar Imam, J.L. Kapoor, A.K. Sarkar, K. Subbarao, and M. Hidayatullah. All were great judges. This verdict has become a locus classicus on the question of contradiction in the realm of criminal law. Now, the later testimony of a witness can be contradicted during his cross-examination with reference to his previous statements in writing or reduced to writing by recourse to Section 145 of the Evidence Act. Section 145 of the Evidence Act reads as follows. Cross-examination as to previous statements in writing. A witness may be cross-examined as to previous statements made by him in writing or reduced to writing and relevant to matters in question without such writing being shown to him or being proved. But if it is, this is more important, but if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. This latter portion of the section 145 of the Evidence Act is more important for contradicting a witness in a case instituted on a police report. Now, Section 145 of the Evidence Act, along with Sections 138, 140, 146, 148, 154, and 155 of the same Evidence Act, constitute the main provisions for impeaching the credit of a witness by cross-examination. If the credit of a witness is to be impeached through cross-examination, these are the usual sections which are pressed into service or which are applicable. For proving a contradiction of a prosecuted witness under the proviso to Section 162(1) of the Code of Criminal Procedure 1898, that is 1898 Code, the majority of 4 judges in Tahsildar Singh's case held that the procedure laid down in the latter limb of Section 145 of the Evidence Act is to be applied, can be made use of. This is what the bench observed. Section 145 of the Evidence Act is in two parts. The first part enables the accused to cross-examine a witness as to previous statements made by him in writing or reduced to writing without such writing being shown to him. The second part deals with a situation where the cross-examination assumes the shape of a contradiction. In other words, both parts deal with cross-examination. The whole section deals with cross-examination. Both parts 1 and 2 deal with cross-examination. The first part with cross-examination other than by way of contradiction, and the second part by contradiction, the cross-examination by contradiction, by way of contradiction. This is what the Tahsildar, the Constitutional Bench held in paragraph 13. You may refer to. I am referring only to the AAR citation. AAR 1959 Supreme Court 10-12. The AAR citation, para 13. The 1898 code was repealed by the Code of Criminal Procedure 1973, which we usually refer to as the 1973 code or even CRPC, which came into force on 1/4/1974 onwards, and we are now governed by the 1973 code. Now, what is contradiction as envisaged by the proviso to Section 167 to CRPC and the latter limb of Section 145 of the Evidence Act? What is contradiction? Neither the Evidence Act of 1890, neither the Evidence Act of 1872, nor the 1898 Code CRPC, nor the 1973 Code, nor any of the corresponding new criminal statutes, define the expression contradiction. But the word contradiction was judicially defined in the celebrated Tahsildar Singh's case as follows. I quote, if the previous statement of the witness before the police officer during the stage of investigation and the later statement of the witness in the evidence before court, that is two statements, earlier statement given to the police during investigation and the subsequent testimony given by the witness before the court during trial. If these two statements are so inconsistent or irreconcilable with each other that both of them cannot coexist, both of them cannot coexist, then it may be said that one statement contradicts the other. See how beautifully put. If both these statements are so irreconcilable or so inconsistent that both cannot coexist, if one is true, the other is wrong. If the other is true, this is wrong. So both cannot coexist. Then it can be said that one statement contradicts the other. You may refer to para 19, end of para 19 of Tahsildar Singh. That if one is true, the other is false. If a witness says, I saw A shooting B dead with a gun. Witness says, I saw A shooting B with a gun. Shooting B dead with a gun. Then he later says, I saw C stabbing B with a dagger. First he said, I saw A shooting B with a gun. Then said, I saw C stabbing B. One is shooting, the other is stabbing. And persons are also, the culprits are also different. So both these cannot coexist. If one is true, the earlier statement is true, subsequent statement is false. And if the subsequent statement is true, the earlier statement is false. So both cannot coexist. This is what is called contradiction, as beautifully stated in para 18 and 19 of Tahsildar Singh's case. Now we come to an important aspect of contradiction. Omission, whether it can amount to a contradiction. Now you may kindly note that omission was not there in when Tahsildar Singh's case was decided. The explanation which we find in section 162 of the 1973 code was absent in the 1898 code. Tahsildar Singh was deciding the 1898 code, section 162 of the 1898 code. In fact, Section 181 of the Bharatiya Nagarik Suraksha Sanhita 2023 BNSS, Section 181 is the corresponding section. There also it does not define contradiction. The provisions are same. Equally, the Constitution bench explained omission. The bench explained the so-called omission in Section 162 of the 1898 Code. They were interpreting the 1898 Code of Criminal Procedure. The observations made by the bench, in fact, are scattered in several paragraphs of the verdict. They are not, in fact, it lacks some coherence. The observations regarding omission lacks coherence in the judgment. They are scattered over different paragraphs. So, for your benefit, I will enumerate those observations in the form of propositions of law. The first proposition is the principle under Section 162 of the 1898 Code is that a witness cannot be confronted with the unwritten record of an unmade statement. A witness cannot be confronted with the unwritten record of an unmade statement. That means a previous statement is inevitable, is necessary, absolutely necessary for even eliciting an omission. An omission can arise only from that statement, not otherwise. Para 23, Tahsildar Singh. Then second proposition is prima facie a statement cannot take in an omission. Unlike the present CRPC 1973 CRPC, prima facie a statement cannot take in an omission. A statement cannot include that which is not stated. This is what the bench said. A statement cannot include that which is not stated. What is stated alone can be a statement. Para 18 of Tahsildar. Then third proposition is statements not reduced to writing by the police officer cannot be used for contradiction. If you want to contradict a witness, there should necessarily be a written statement by the witness to the police officer during investigation. Either written statement or a statement reduced to writing. That is a must. Whether you and there what was contemplated was only contradiction. Omission was not there. Express omission was not there. So they held that this omission could arise only from that statement, not otherwise. So a written statement is a must. Para 26. Then although a particular statement is not expressly recorded, a statement that can be deemed to be part of that which is expressly recorded can be used for contradiction, not because it is an omission strictly so called, but because it is deemed to form part of the recorded statement. See, there is the beauty in which it has to be deemed to be part of the recorded statement, omission. You may refer to para 26 of Tahsildar Singh. Then yet another proposition. While a bare omission can never be a contradiction, a so-called omission may sometimes amount to a contradiction, provided it forms an inferential part of the statement in writing. Para 29 of Tahsildar Singh. The principle of inherent repugnancy may in one sense rest on omissions, but by construction, the said omission must be deemed to be part of the statement in writing. Such omissions are not really omissions strictly so called, and the statement must be deemed to contain thereon by implication. So the omission must be deemed to contain thereon by implication. A statement, therefore, in our view, not only includes what is expressly stated therein, but also what is necessarily implied therefrom. Para 18, beautifully stated by Justice K. Subbarao. Then the Constitution bench observed as follows. Contradiction under Section 145 of the Evidence Act is between what the witness asserted in the witness box during trial and what is stated before the police officer. Contradiction is between these two statements. That is, what he asserted in the court, in the witness box in court, and his previous statement given to the police during investigation. These two statements are to be compared for eliciting a contradiction. And not, this is more important, and not between what he said he told the police. What he said he told the police and what he actually told the police officer. That is, the witness cannot be allowed to say something which is not there in his 161 statement recorded by the police officer. So you can't hear him to say that I told the police officer such and such made such and such statement. If that statement is missing or absent in the recorded statement recorded by the police, he cannot introduce that statement. That is why the contradiction is not between what he said he told the police officer, but and what he actually told the police officer. What he actually told the police officer is there in black and white before the court. So you cannot allow him to say something which is not there. This is what beautifully stated in para 13 of Tahsildar Singh. Again, it was observed. Contradiction means the setting up of one statement against another and not the setting up of a statement against nothing at all. You can only set a statement against another statement. If there is no other statement, you cannot set one statement against nothing. It's a logical corollary to what they earlier said. That is para 11. I'm sorry, para again 23 of Tahsildar Singh's case. This proposition in Tahsildar was subsequently followed by the Supreme Court in Shashidhar Purandar Hegde versus State of Karnataka, area 2004 Supreme Court 5075. 2004 Supreme Court 5075 by Justice Harit Pasai speaking for the bench. Other judge was C.K. Thakkar. So according to the bench, the prosecution witness could not be asked by the cross-examining counsel something which was not there in his statement to the police. But an omission could be inferred in the previous statement of the witness by way of necessary implication. The bench gave the following illustrations. Now, illustrations will elucidate the proposition. First illustration was, in his testimony before court, a prosecution witness says, I saw the accused running away in court during trial. But in his statement, previous statement to the police, he, under section 161, what he told was, I did not see the accused running away. So before police, he said, I did not see the accused running away. Before court, he said, I saw the accused running away. Now, what the defense counsel asked the witness is, did you tell the police that you saw the accused running away? There is no statement that he saw the accused running away. He did not see the accused running away is a statement. So the defense counsel asked, did you tell the police that you saw the accused running away? That is a statement in court. The witness answers, yes. I stated to the police that I saw the accused running away. The above question could not be put and such an answer could not be elicited by the cross-examining counsel from the witness. Because his statement to the police was, I did not see the accused running away. So he is asked, did you not tell the police that you saw the accused running away? That is a statement in court only. He did not say to the police that he saw the accused running away. Now, you may refer to para 23 of Tahsildar Singh's case, where this illustration is given. This was again followed by the Supreme Court in R.K. Dalmia versus Delhi administration, 3 judges. Raghubar Dayal speaking for the bench. Again, Shashidhar Purandare Hegde, I already gave the citation. AR 2004 Supreme Court 5075, Justice Arijit Pasai speaking for the bench. Then the second illustration given by Tahsildar Singh is, what the witness told the police was, D stabbed C. D stabbed C. But what the witness deposed before court during trial was, B stabbed C. First is D stabbed C. Here in court, B stabbed C. This is a clear case of contradiction. Both cannot coexist. If one is true, the other is false, necessarily false. So this illustration is referred to in para 13 of Tahsildar. Third illustration, witness A made a previous statement to the police. I saw B stabbing C to death. I saw B stabbing C to death. C was stabbed to death. But he saw B stabbing. But in deposition before court during trial, A stated, I saw B and D stabbing C to death. B and D stabbing C to death. D was also added. Now, here the previous statement of the witness to the police does not contain a statement as C deposed before court. He said, I saw B stabbing C to death. And court, he said, I saw B and D stabbing C to death. So D was added before the court. In the statement to the police, D was not there. B alone was there. Now, here the omission is, what is omission? Not the addition of D, but the earlier statement to the police should be read as, I saw B only stabbing C to death. I saw B only. Only is the inferential omission which can be attributed to the statement given by the witness to the police, and not and D. And D is not the inferential omission. I saw B only stabbing C to death. Whereas in court, B and D stabbing C to death. And D is not the omission. That is actually an addition. So omission is B only. I saw B only. So B only is to be inferred from the earlier statement given to the police. That is the inferential omission spoken to by the Constitutional Bench. Fourth illustration. Witness stated to the police that he saw 3 persons beating a man. He saw 3 persons beating a man. Later, witness stated in court that 4 persons were beating the same man. So before police, 3. Before court, 4. So 1 was omitted in the statement to the police. It was held that the so-called omission amounted to here the so-called omission amounted to a contradiction in not mentioning the 4th man before the police. This is para 23 of Tahsildar Singh. Thus, the bench concluded that an omission under section 162 of the 1898 code must be deemed to be, by necessary implication, a part of the previous statement of the witness made in writing to the police. An omission in that statement is to be necessarily inferred from what is directly and expressly stated by the witness to the police. You may refer to paragraphs 18 and 26 of Tahsildar Singh. Now, what is the direct consequence of explaining the omission in Tahsildar Singh's case? The above view taken in Tahsildar Singh's case, interpreting section 162 of the 1898 code, means that the defense counsel, or rather the cross-examining counsel, cannot ask the prosecution witness, either by a leading question or otherwise, something which is not there in the 161 statement given by the witness to the police. By asking such a forbidden question and fishing out an affirmative answer from the witness, the defense counsel cannot put forward the said answer as an omission amounting to contradiction. This is because the defense counsel, by suggesting to the witness a statement which is not there in his police statement, is really creating a statement by the witness to the police, which is not there. But the law, as laid down as above in paragraphs 18, 23 and 26 of Tahsildar Singh's case, interpreting section 162 of the 1898 code, does not hold good now in view of the explanation to section 162 of the 1973 code. I wanted to highlight this aspect of omission amounting to contradiction. In fact, I had put a question to a few lawyers groups and judges groups. The question put to us, I read the question. The celebrated verdict of a 6 judges constitutional bench of the Supreme Court of India in Tahsildar Singh versus State of UP, AIR 1959 Supreme Court 1012, is considered to be the locus classicus on contradiction. It was inter alia held in that verdict that an inferential omission, if material, could amount to a contradiction within the meaning of section 162 of the 1898 code. Now, my question is, does not the interpretation of omission given in Tahsildar Singh's case hold good under section 162 of the Code of Criminal Procedure 1973? It does not, because of the explanation which has been incorporated in section 162 of the 1973 code. I wanted to highlight this aspect because I noted there is at least some lawyers and some judges still laboring under the misconception that what was laid by Tahsildar Singh regarding omission is the law even now applicable. No. In fact, we were also taught in the Judicial Academy that Tahsildar Singh proposition is the law. But unfortunately, this aspect was not highlighted. Therefore, we were also to some extent during some period laboring under this misconception. Now, there was a dispute between the judges who decided Tahsildar Singh's case as to which part of section 145 of the Evidence Act could be used for contradicting a prosecution witness. The minority judges consisting of Justice M. Hidayatullah and Justice Said Jafar Imam held that the defense counsel can cross-examine the prosecution witness not only to elicit a contradiction under the second limb of section 145 of the Evidence Act, but also cross-examine the witness by resort to the first limb of section 145 of the Evidence Act. You may refer to paragraphs 40 to 58 of Tahsildar Singh's case, where you find the minority view. But the majority comprising of 4 judges, led by Justice K. Subbarao, held that in view of the proviso to section 162(1) CRPC, which allows a contradiction alone to be proved, the cross-examination of the prosecution witness with regard to his previous statement should be confined only to the second limb of section 145 of the Evidence Act. You may refer to para 13, majority view is reflected in para 13 of Tahsildar Singh's case. Now, how does a contradiction arise? And what is the procedure for contradicting a witness? How does a contradiction arise? See, a contradiction as envisaged by the proviso to section 162(1) CRPC 73 code arises in the following manner. Supposing the case is a case instituted on a police report, the police officer during investigation would have interrogated the witness, the prosecution witness. Now, section 161(1) says a police officer conducting an investigation under chapter 12 CRPC may orally examine any person supposed to be acquainted with the facts and circumstances of the case. Then, now, may any person supposed to be acquainted with the facts and circumstances. It does not say witness. It does not say the police officer may orally examine only any person supposed to be acquainted with the facts and circumstances of the case. This expression was held to include an accused person also. Therefore, the police officer during investigation can not only orally examine a witness, but also even an accused. The citations are, in fact, AIR 1932 Madras 391, full bench, Chamo Maha Patro versus Emperor was approved by the Privy Council in Pakala Narayana Swami versus Emperor. AIR 1939 Privy Council 47 by Lord Atkin, the great judge Lord Atkin. This Madras High Court full bench was approved to hold that that expression will any person will include an accused person also. Then Kerala High Court also in division way back in 1971. Velu Vishwanathan versus State, 1971 KLT 80, a division bench by T.C. Raghavan and E.K. Moidu. T.C. Raghavan is the author of the judgment. They also took the view that any person will include an accused person. Then yet another division bench of Kerala High Court, Matthew Sekaria versus State of Kerala, 1974 KLT 42, Justice V.P. Gopalan Nambiar and George Vadakale, Justice Gopalan Nambiar being the author of the judgment. They held that any person mentioned in section 160 will include an accused person also. Then came the Supreme Court, para 39 of Mahabir Mandal versus State of Bihar, AR 1972 Supreme Court, 1331. 3 judges, Justice James Shelat, H.R. Khanna and G.K. Mitter. H.R. Khanna being the author of the judgment. Way back in 1972, they held that Of course, Privy Council has already held so. And any person will include an accused person also. Then came Nandini Satpathy versus P.L. Dani, Justice V.R. Krishnaiyer, Jaswant Singh, and V.D. Tulsapurkar. Justice Krishnaiyer being the author. A.R. 1978, Supreme Court 1025, 3 judges. They also took the same view. Then of late, Deepak Bhai, Jagadish Chandra Patel versus State of Gujarat. A.R. 2019, Supreme Court 3363, 2019 Supreme Court 3363. Ashok Bhushan and K.M. Joseph. K.M. Joseph being the author of the judgment. All these judgments held that any person who is supposed to be acquainted with the facts and circumstances of the case will include an accused person also. Now, after orally examining a person, the police officer may reduce into writing his statement under section 161.3. Under 161.1, he can orally examine. Then under section 161.3 CRPC, he can reduce his statement into writing. So, statement given by a witness, during the subsequent trial before the court, it is that statement reduced into writing by the police officer under section 161.3 CRPC, which is matched with the testimony of the witness in court, both by the prosecutor as well as by the defense lawyer. So both of them should be vigilant and they should be thorough with the 161 statement of the witness and his testimony before court. And if the testimony of the witness in court and his irreconcilable statement given to police officer cannot stand together, the cross-examining counsel will have to first ask the witness whether he made such a contradictory statement to the police. So supposing there is the statement by the witness before police officer and the statement by the witness before court during trial are diametrically opposite. The subsequent statement is diametrically opposite to the previous statement of the witness given to the police officer. Then the cross-examining counsel will have to ask the witness, did you say so to the police officer? We find a contradiction. What you said in court is diametrically opposite to what you told the police officer. Did you tell the police officer in such a way that portion of the statement can be read over to him? And if the witness admits, there ends the matter. It is proof. But if the witness denies, the procedure is to provisionally mark the contradictory part of the statement subject to proof. To provisionally mark the contradictory portion of the statement in the police statement subject to proof. When does the proof come? He has denied. When does the proof come? Proof comes when the police officer who recorded the statement from the witness is subsequently examined before court. The police officer will look into the 161 statement and say that, yes, this witness told me so. This witness had given me such a statement. That there the contradiction is proved. In a case where the witness denies having stated the... Now, before marking the contradiction, there is one requirement under the latter half of section 145. What is that? That contradictory portion of the statement given by the witness to the police, his attention should be drawn to that. His attention should be drawn to the contradictory part of the statement, and his explanation has to be elicited by the cross-examining counsel. See, Mr. So-and-so, you seem to have given such a statement to the police officer during investigation, but you stated just the opposite now before court. Now, what have you got to say? Why did you make such a contradictory statement before the police officer? He may have so many explanations. So it is a situation where the principle of natural justice, odi alterum partem is applied, because you are going to discredit the witness for giving such contradictory statements, one before the police officer and other before the court. So before discrediting the witness, before disbelieving the witness, You have to ask his explanation. You seem to have said so. What have you got to say? That's a requirement under the second half of section 145 of the Evidence Act. That is the procedure under section 145 of the Evidence Act. Now, this is how the contradiction is marked. If it is denied by the witness, it is provisionally marked subject to proof. Proof will come from the officer, police officer who recorded the statement. If on the contrary, the witness himself admits that, it is proof. There is no further requirement of examining the police officer is necessary. This has been beautifully stated in para 13 of Tahsildar Singh's case, and subsequently in paragraphs 18 and 19 of V.K. Misra versus State of Uttarakhand, AR 2015, Supreme Court 3043, 3 judges, D.S. Thakur, R.K. Agrawal, and R. Bhanumati. The author of the judgment is R. Bhanumati. Now there is a process of the re-examiner explaining the contradiction. Now there is a contradiction made out. A contradiction has been brought on record by the cross-examining counsel. Contradiction of the prosecution witness has been brought on record by the cross-examining counsel. Now, can the opposite side, that is the prosecutor, can the public prosecutor try to explain that contradiction? That is also provided in the proviso to section 162(1) CRPC. Now, the latter portion of the proviso to section 162(1) CRPC also says that when any part of the statement of a prosecution witness to the police is used for contradicting the witness, any part of such statement may also be used in the re-examination of such witness, but only for the purpose of explaining any matter referred to in his cross-examination. Now, what does this mean? What does this mean? Re-examination, even under section 138 of the Evidence Act, should only be for explaining any matter referred to in the cross-examination. The purpose of incorporating such words, the above words in the latter half of the proviso to section 162(1) CRPC, is again to make admissible a portion of the 161 statement of the witness, presumably to save him from being discredited, if possible. I will give an illustration. A prosecution witness A in a murder case deposed before court in chief examination. I had seen the accused running away from the house of the deceased, and at that time the accused was having a chopper in his right hand. He saw the accused running away from the house of the deceased with a chopper in his right hand. This is what he deposed before court in chief examination. But what he told the police in his 161 statement recorded during previous investigation was, I saw the accused running away from the house of the deceased with a knife in his right hand. In court he said chopper in his right hand. In police he said with a knife in his right hand. Now this is a clear, definitely a contradiction. Now the defense lawyer during cross-examination will promptly bring out the above contradiction on record. Supposing the 161 statement of the witness further stated, I am not very sure whether the weapon which the accused was carrying was a knife or something else. He first stated in the police statement that I saw the person running away with a knife in his right hand. That is the police statement. Subsequently, he also says, I am not very sure whether it was a knife or some other weapon. He is not very sure, though he said knife initially. So now the public prosecutor during re-examination can definitely elicit the above statement to the police to explain the contradiction with a view to avoid the witness being discredited. Strictly speaking, this process is what is this process of eliciting a further statement in the police statement is really a corroboration. Actually, you are eliciting a corroboration, but only to explain the contradiction. The contradiction which has already come on record. In order to explain that contradiction, if possible. See, every case this cannot be done. Fortunately, luckily, this statement of the accused to the police also contained a subsequent statement that even though I mentioned a knife, I am not very sure about the weapon. I had only a fleeting glimpse. Therefore, I am not very sure of the weapon. Therefore, that statement can certainly be made use of by the public prosecutor to explain the contradiction which has already come on record. By doing that, you are actually bringing into focus a corroboration, but that is a limited. It is provided by the section itself. Now, what is the extent to which the total ban under section 162(1) of the 73 code, 1973 code, earlier also, same code also, and section 181 of the BNSS also operates. There is a total ban under section 162(1) CRPC against the use during any inquiry or trial of any statement made by any person to a police officer in the course of an investigation under chapter 12 of CRPC. But the proviso to section 162(1) CRPC partially lifts the above ban in the case of a prosecution witness, and that too only for proving a contradiction in the manner provided under section second limb of section 145 of the Evidence Act. So, what is the special feature of a statement under section 160 of the total ban under section 162(1)? The ban under section 162(1) against the user of the statement recorded under section 161 is a total ban. It's a total interdict, total embargo against user of that statement. But in the case of a prosecution witness, it is partially, that ban is partially lifted, and that too only for proving a contradiction, not a corroboration, for a contradiction. Now, this contradiction can be proved only in the manner provided under the second half of section 145 of the Evidence Act. If a prosecution charge witness, supposing a prosecution charge witness whose statement was recorded under section 161(3) CRPC by the police officer was given up by the prosecution. A prosecution charge witness who was questioned by the police and whose statement was recorded was given up by the prosecution during trial, and he is examined by the defense as a defense witness. Defense can examine a witness given up by the prosecution. He is examined as a defense witness. Now, cannot his 161 statement be used for contradiction and corroboration? No, because of the total ban under section 162(1) CRPC. He is no more a prosecution witness. He is no more a witness called for the prosecution within the meaning of the proviso to section 162(1) CRPC. Therefore, this witness, even though he was a charge witness, even though he was a prosecution witness, but he was given up by the prosecution, and now he is appearing as a defense witness. So, the proviso will not come to the rescue. His statement cannot be used for any purpose as provided under section 162(1) CRPC. Now, same is the position of a court witness. Supposing such a charge witness is examined as a court witness. Nobody examined him, but the court examines him. There also, the bar under section 162(1) CRPC will apply. Of course, there are decisions to the effect that the court, this provision, the power of the court under section 165 of the Evidence Act will override this power. Court can always make use of the statement by resort to section 160. There is a line of ruling to that effect. We are not on that. That will not apply except in a court witness. So this is the extent of the total ban, the impact of the total ban under section 162(1) CRPC. Now, the extent to which a prosecution witness can be discredited. Now, depending on the importance of the contradiction, the prosecution witness may be discredited wholly or in part. If it is a material contradiction, court may in a given case discredit him as in a whole. But if it is not a significant omission or significant contradiction, court may ignore the same and still accept the testimony of the witness, because the maxim falses in uno, falses in omnibus, falses in uno, falses in omnibus, meaning false in one particular aspect, false in all aspects. That proposition, that maxim has no application in India. Therefore, notwithstanding the hostility exhibited by a witness on a particular aspect, the witness can still be believed on any other aspect. There are a lot of rulings on that. Notwithstanding the witness is not reliable on a particular aspect, you cannot exclude a testimony of the witness as a whole. Other parts of the evidence of the witness can still be believed by the court. Now, omission amounting to contradiction under the 1973 code. 1973 code. The restricted interpretation of an omission amounting to contradiction as indicated in paragraphs 13, 18, 23 and 26 of Tahsildar Singh's case is no more relevant in view of the explanation to section 162 of the 1973 code. Such an explanation was not there when the Tahsildar Singh was interpreting section 162 of the 1898 code. And said explanation, I will read the explanation. An omission to state a fact or circumstance in the statement referred to in subsection 1 may amount to contradiction if the same appears to be significant and otherwise relevant, having regard to the context in which such omission occurs, and whether any omission amounts to a contradiction in the particular context shall be a question of fact. So thus, an omission under section 162 of the 1973 code is what is an omission? Now, it is a material improvement or embellishment. Supposing in court he comes out with a material improvement than the statement given to the police, or material embellishment in court, it has been stated, then it is covered by the explanation, and the defense lawyer, the cross-examining counsel, will be justified in asking him whether such a statement made by him in court, whether he did make such a statement to the police, even though the statement of the police is silent about such a statement. While Tahsildar Singh, interpreting 1898 code, said that for making out an omission, there should be a statement, and the omission can only part of an inferential part of the statement. But now there need not be a statement at all. If the prosecution witness were to make a statement in court, which is absent in his 161 statement, the cross-examining counsel can definitely ask him, did you say this before the police officer when you were questioned, when you were interrogated? The principle of interpretation under section 162, 1898 cannot be confronted with one. Now, the 1898 principle was that a witness cannot be confronted with the unwritten record of an unmade statement to the police. That principle has no application under the 1973 code in the light of the explanation to section 162. Now, if you want a few instances where omission amounting to contradiction was considered by the Supreme Court under the 73 code, in State of Punjab versus Parveen Kumar, AIR 2005 Supreme Court 1277, BP Singh and Arun Kumar, judgment by BP Singh, where the witness deposed before court that the deceased had made a dying declaration to him. But in his statement, the witness recorded under section 161, he did not say about any dying declaration. Dying declaration was absent in his police statement. But when he deposed before court, he said that there was a dying declaration. To that extent, the omission was, he was not believed because of the conspicuous, significant omission in his 161 statement. Then yet another case is Witness stating in court that he had gone to this spot on hearing the sound of gunshot and tried to snatch away the gun from the accused. In court, he deposed, I went to the spot on hearing the gunshot and sound, and I tried to snatch away the gun from the accused. But before the police, he had no such case. It was amount to a serious contradiction in the form of omission in the form of contradiction. The citation is State of Rajasthan versus Rajendra Singh, AIR 1998 Supreme Court 2554. GT Nanavati and SP Kurdukar. GT Nanavati is the author. Again, version of the prosecution witness in court was that accused used lathis, but such a version did not find a place in their police statement. The prosecution case was not upheld by the court because of this fatal omission. State of UP versus Bannu, 2009, Volume 4 SEC 271. Dalbir Bhandari and Harjit Singh Bedi. Dalbir Bhandari and Harjit Singh Bedi. Yet another case, Meera versus State of Rajasthan, 2004, AR 2004 Supreme Court, 1879, Justice Santosh Hegde and BP Singh being the author of the judgment. There the facts was, father of the deceased alleging in court for the first time about torture of his daughter by the accused mother-in-law. There was no mention of any such torture in the police statement given by him. Therefore, he was disbelieved by the court because of this important, significant omission. Then there's yet another case. Witnesses in the statement under Section 161 CRPC were attributing a clear intention on the accused to commit murder of his wife, but stating before Session Court that accused was insane, behaving like a madman. So this contradiction in the form of omission in the form of contradiction were highlighted by the Supreme Court. AR 1964 Supreme Court 1563. Dayabai Chaganbai Thakkar versus State of Gujarat. AR 1964 Supreme Court 1563. Judgment by K. Subbarao, who authored the leading judgment in Tahsildar Singh's case. Then one other case I will just mention only to find out the distinction. It was held that the omission on the part of PW 3, 4 and 8 in not stating before court that there had been exhortation on the part of the accused person as stated by them before the police would amount to contradiction. What they stated before court, they omitted to state before, what they stated before the police, they omitted to state before the court. This was held to be an omission amounting to contradiction. But is it really an omission amounting to contradiction? Here the omission is in the statement before court, not in the police statement. If you read explanation, I have already read the explanation. If you read the explanation, an omission can only be in the police statement, not in the statement before court. Therefore, actually, this is not an omission, even though the Supreme Court held in Sri Gopal and another versus Subhash and others. AR 2004 Supreme Court 4900. AR 2004 Supreme Court 4900. Doraiswamy Raju and S.B. Sinha. Justice S.B. Sinha being the author of the judgment. It is really surprising that how did this aspect escape the notice of Justice Sinha, who was a great judge. So in conclusion, what I would say is that under Section 162 of the 1898 Code, which was the provision interpreted by Tahsildar Singh's case, AR 1959 Supreme Court 1012, a previous statement to the police was inevitable and necessary, and omission amounting to contradiction could arise only if such an omission could be deemed as a necessary inference to the part of such previous statement. There had to be a previous statement under Section 162 of the 1898 Code. But under Section 162 of the 1973 Code, In view of the explanation to that section, a previous statement to the police on a matter testified before court by the prosecution witness can constitute an omission. Consequently, the view taken in Tahsildar Singh's case and other verdicts interpreting section 162 of the 1898 code to the effect that it is not open to the cross-examining counsel to ask the prosecution witness whether he had made any previous statement to the police on a matter in respect of which the witness deposed before court for the first time is no more applicable in a prosecution under the 1973 code. To put it differently, if a prosecution witness made before court a statement for the first time, it will be open to the cross-examining counsel to ask the witness whether he or she made such a statement when interrogated by the police during investigation. Whereas under the 1898 code, such a question could not be asked if there was no statement at all. Here, there is no need for any statement at all. The cross-examining counsel can still ask whether you said so before the police, what you said now in the court. That is the distinction. This will answer my question which was put to many of the lawyers and judges. Thank you. This much on contradiction. I think my voice has started cracking.
Just saying, because on the YouTube we don't have any question. You have such elucidatedly explained the session that there's no question on the YouTube or as well as on the chat.
Okay.
Yeah.
So that means they did not understand anything.
No.
Or they understood everything.
They understood everything.
Okay.
Thank you, sir. Thank you for sharing knowledge. And tomorrow, at 6 p.m., we will have a session on bail. What are the changes brought forth in BNS vis-a-vis the old law? So stay connected tomorrow at 6 p.m. by MS Shyam Sundar, a senior advocate from Kerala High Court, Karnataka High Court. Do stay connected.